initiate the live streaming.
Streaming live.
The Supreme Court of Guam is now in session. Good afternoon, counsels, and will the clerk please call the case?
This is Supreme Court case number CRA20-002. People of Guam, Plaintiff Appellee versus Red 12 Tefong, Defendant Appellant. Appearing for the Plaintiff Appellee is Attorney Marianne Wallachuk. Appearing for the Defendant Appellant is Attorney Peter C. Paris. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Paris reserves 5 minutes.
Thank you. Attorney Paris, you are recognized.
Good afternoon, Chief Justice Carbolito, Justice Torres, and Justice Merriman. May it please the court. Mr. Tefong appeals his convictions that were returned on insufficient evidence and based upon a facially invalid statute. For these errors, he asks this court to grant him acquittal, reversal of the convictions, or such other relief this court may deem proper. Both issues raised on appeal are subject to a de novo standard of review. And with respect to the issue of sufficiency of evidence, Mr. Tefong preserved his ability to argue this on appeal, having asserted motions for acquittal at the close of the people's case, at the close of his case, and after the jury returned verdicts. With respect to this issue, the standard is rather high. This court reviews the evidence presented at trial in the light most favorable to the people and determines whether any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt, and this is a highly deferential standard of review. Notwithstanding this high standard, we submit that the evidence was insufficient to convict Mr. Tefong of each of the charges for which he was convicted. Specifically, with respect to the terrorizing conviction, we're instructed from this court's decision in Camacho that we look to the substance and context of the threat. And we submit that the evidence in this case showed that the statements attributed to Mr. Tefong were innocuous, made in a non-serious manner by one friend to another, while all were apparently intoxicated. He had the ability to carry out any threat if he chose to do so, and the alleged threat was neither genuine nor actual. In looking at the evidence that was presented, I would note that there's one victim named in the indictment, and that's Chris. And Chris testified that prior to the incident, she knew Mr. Tefong. He was a friend of hers. And she testified to September 25th, 2018. On that day at around 4 or 5 o'clock p.m., she met with Jenny in Mighty near the Hong Kong store, where they sat together, and within a period of a half hour, she drank 3 beers. After finishing the 6-pack between them, they started walking towards the Chamorro village. And while doing that, they encountered Mr. Tefong and another male. According to her testimony, they asked them to buy more beer. Chris told them they didn't have any money to buy beer. And according to her testimony, Tefong then said he was going to use a machete to cut her and Jenny. He was going to cut her on the belly and Jenny on the neck, and that she said Tefong had the machete on the inside of his shorts. She testified that she was scared and that they ran to the Hong Kong store where they called the police. But she agreed that Mr. Tefong did not cut her with the machete. He never touched her with it. He never used it. He never swung at her with it. And then we also heard testimony from Jenny, who was with her. And I just want to emphasize that Jenny was not named as a victim in the indictment. And among her other testimony, she was asked, when you saw Tefong with the knife, what else happened before you called the police? Did anything else happen? And she replied, no, he's just telling us that, just telling us that. We know from their testimony and from the testimony of the Hong Kong store owner that they both went to the store. They claimed they ran to the store where they called the police. They were in the store for 10 minutes, and then they went outside. And when they went outside, Mr. Tefong and the other individual were in their presence, approximately 20 to 30 feet away, where they remained until the police arrived. We know that the police arrived, according to police testimony, minutes after the call was made. And when police did arrive, officer testimony was that they found the defendant and the victim together. They were 20 to 30 feet apart. Everyone seemed calm. There was no need for any force at the time because there wasn't any threat presented. Mr. Tefong was standing there. He didn't run from police. He cooperated. No machete was being brandished, and the victims were not checked for injuries. Some police testimony said that when they arrived, Miss Chris was screaming, that she was screaming at the top of her lungs, and that she was saying that, pointing in the direction of the men, saying that they were trying to rob her and that one of them was going to cut her with a machete. That was some police officer testimony. Officer Castro said that Mr. Tefong had time to
Mr.
walk.
Perez, I noticed you did point out that there may be some conflicts in the evidence and presented between Jenny and the named victim John's version of events and potential issues of witness credibility that are raised during the trial. But really, we can't pass upon or resolve those conflicts or discuss the credibility of the witnesses or even weigh the evidence. That's all matters for the jury. And so looking at, the standard of review and, understanding how we're supposed to evaluate that, it's very difficult for us to go through, I think, and determine that, the conflicts in evidence that you might point, whether or not Ms. John was in reasonable fear of being threatened when he, said the comment that he said, or whether it was just a friend joking to another friend. I mean, the jury heard all this evidence and made their determination.
Right, and that's the difficulty with these types of issues. And that's the limited scope in which this court evaluates this argument. And I understand that. But when we do look at the evidence according to the standard for these types of motions, what did Ms. Chris do when the threat allegedly was made? She went to call the police, she said, and then she came outside and stayed with him for 20 to 30 feet away. She didn't stay inside the store. She didn't avoid him when he went outside. So I think we look at what the evidence that was presented and look at whether a rational trier of fact could have found that evidence proved the allegation. And I would submit that based upon the evidence that was presented and the findings of the court in the context of evaluating the acquittal motions, that there was insufficient evidence, and this court does have the ability, if the court finds that no rational trier of fact could have found conviction, to acquit Mr. Tefong on appeal. So looking at the testimony of Chris, looking at the testimony of Jenny and the police officers, and finally the court's own findings, noting that, the court made very significant findings when it was evaluating it. What did the court say? It was, the court says, well, possession, it wasn't used because the machete didn't hit anything. And so, he possessed, and possession is sufficient, albeit made a threat with it, but he didn't use it. He didn't take a swing at anybody. He didn't use the machete in the sense that he didn't hit anybody with it. He could have easily hit him with it. He could have done, there's nothing that prevented him from taking the machete and hitting Chris with it. There's nothing that would have prevented him from, he had so much time to chop Chris up if that's what he wanted to do, or even strike Chris. All four were intoxicated. Well, he had a machete. His words were, I'm going to cut you with a machete, and he had a machete. Is there anything over that he did? He asked the prosecutor, who responded, no, Your Honor. So, I mean, those were the court's findings. And when we look at the remaining charges for which he was convicted, like the special allegation, we have, with respect to the component of possession, we know from the police testimony and from the evidence at trial, no machete was presented as evidence at trial. There was oral testimony that he possessed a machete, but there was not an actual machete. It was not preserved for evidentiary purposes nor introduced at trial in evidence. Even if there was proof of possession, there was no unlawful possession under the law. The possession was legal. No machete was being brandished. There wasn't any threat presented when the police came. The police said it wasn't a crime for him to have the machete in his shorts. And he never used the machete unlawfully. He didn't cut her with it. He didn't touch her with it. He didn't use it. He didn't actually swing it at her.
But for the special allegation, the people aren't required to prove the use of the deadly weapon in the commission of a felony. They're only required to prove unlawful possession. And so at the time that the threat was allegedly communicated, he had taken out the machete from under his clothing. And so even though he didn't touch her with it or swing it at her or carry out his threat of cutting her throat and belly, why doesn't that constitute at the minimum possession and even use, since he pulled it out from his shorts?
So under the statute, 9 GCA 80.37, and under the essential elements as instructed by the court to the jury, the prosecution had to prove that on September 25th, 2018 on Guam, Mr. Tefong knowingly and unlawfully possessed or used a deadly weapon, that is a machete, in the commission of a felony, that is terrorizing. So with respect to use, court found he didn't use it. The testimony suggests he didn't use it. And with respect to possession, yes, there's testimony he possessed. The question is, was it unlawful possession? The police officer who testified told the jury that it was not unlawful for him to have that machete on his person, in his shorts. So I would submit that there's no unlawful, assuming we get past possession, there's no unlawful possession. And if the theory is unlawful use, the court made findings that there was no unlawful use, and we agree with those findings. So we submit that with respect to the terrorizing and with respect to the special allegation, acquittal should have been granted and that there was insufficient evidence. Similarly, with respect to the fourth charge for which he was convicted, misdemeanor assault. Under 19.30, a person is guilty of assault if he either recklessly causes or attempts to cause bodily injury to another. Well, there's no evidence that he recklessly caused bodily injury to Miss Chris, nor is there any evidence that he attempted to cause bodily injury to her. There's just none. And I don't think that is disputed by the people in their opposition brief. It's clear he didn't cut, swing, or injure her. And the GPD noted that GPD did not conduct injury checks of Miss Chris, and there was no testimony as to any injuries whatsoever. And taken along with the court's findings regarding, the machete didn't hit anything, he didn't use it, he didn't take a swing at anybody, et cetera, there's no way that the fourth charge could have been sustained, and it should not be sustained. So again, while the standard is high, under Camacho, we look to, for the terrorizing, we look to the substance and context of the threat. And that, what we submitted in our brief, is what we believe the substance and context was. And we don't think a rational juror could have convicted Mr. Tefong of the terrorizing charge within the context of the facts of this case. And following this error is the concern that the terrorizing charge for which he was convicted was facially invalid. This is also subject to a de novo standard of review. And we submit that it's facially invalid because it does not state a mens rea, require criminal intent, establish a standard of conduct, require a threat be imminent, require an overt act, and appears to encompass both innocent and criminal conduct alike. When we look at the reading of the statute under 19.60, it says a person is guilty of terrorizing if he communicates to any person. So I want to stop there for a moment and focus on if he communicates to any person. I would point out that there's no mens rea there. Does he have to intend to communicate? Does he have to knowingly communicate, recklessly or negligently communicate a threat to another person?
What about the filler language that's contained in 9 GCA 4.4, which provides that if a definition of a crime doesn't expressly prescribe a culpable mental state, a culpable mental state is required and is established only if the person acts intentionally, knowingly, or recklessly. So why can't there be a reliance on the mens rea that's provided by 9 GCA 4.40?
Well, the base of the statute does not provide a mens rea. I think that's clear. I understand the court's comment, and we do have that statutory provision. But the concern about whether or not a statute is facially invalid or not, you go to the issue, one way of approaching it is whether it's vague. And is it vague to citizens who are conducting themselves on a day-to-day basis? Is it vague to law enforcement who are tasked with enforcing the statute? And is it vague to the triers of fact who are tasked with determining whether or not essential elements have been met? So that's how we.
If I can just interrupt here for a minute. Even setting aside the filler statute, as just Torres points out at 4.40, that when a mental state is not specified, then this provision sets out the mental state that can be utilized. But doesn't the legislature have the authority in reference to passing a statute that may not require a mental state? I mean, in terms of the terrorizing statute, just the overt act of to communicate to any person a threat to commit a crime of violence, and the reaction that it puts the person who the threat is directed to in reasonable fear are the elements of the statute that constitutes the crime of terrorizing. Even assuming, in this case, the judge did the filler and said that it has to be done knowingly. But if that was not done, why couldn't the legislature specify within its authority that there are certain crimes that may not require a culpable mental state?
Well, I do agree that it's the legislature's prerogative to legislate and to enact and to create laws, and inclusive in those laws, mens rea or no mens rea. But it's this court's prerogative to determine whether or not what the legislature does passes constitutional, legal, statutory, or other muster. And it appears, clearly this is a statute that was created by the legislature, but we present it to your honors and say, this is a facially invalid law. I mean, even if there isn't an issue as to the filler and inserting knowingly or intentionally, what about the imminence? What about the time frame? Could somebody make a threat with an undefined time frame, and could the person then say, 2 weeks later that they were afraid, or a year later? It's just not clear what is permitted and what is not permitted. So while there are some ways that the statute, some of the arguments we make might be addressed, overall, we still don't have.
In your hypothetical in terms of eminence, because I don't think the statute contemplates that, in where the threat is a year apart from the reaction. I think then the second element of reasonableness was the person who this threat was made 1 year before. Can it be said that that person was in reasonable fear of his or her life, that a year later there was no act on that threat? And so I think in that case, if you were to satisfy the elements of the statute, I don't think it would have been reasonable for that person to think that he or she was that that it was a reasonable fear that a crime would be committed of violence.
And I understand Your Honor's point, and I would just respond by saying it certainly does give law enforcement broad discretion to decide whether or not the terrorizing statute has been violated. If we don't have an imminence requirement,
But what about the reasonable fear requirement? That in order for there to be a violation of the terrorizing statute, that the person in which the threat of committed crime of violence, dangerous to human life, that person must have a reasonable fear that the crime will be committed. Doesn't that provide some measure of objectivity that law enforcement can just say that the threat constitute a terrorizing act when there is no objective measure, when there is an objective measure as to whether or not that fear is reasonable or not?
Certainly, yes, there is that language in the statute which requires the reasonableness. And certainly law enforcement would have to look at that in assessing whether or not a crime, they believe the crime has been committed. But I would still submit that it's insufficient because we don't have imminence. And giving law enforcement the ability to, or requiring them to undertake that type of analysis with such a broadness of possibilities, I think renders the statute insufficiently clear. I do recognize, yes, there's language in here that gives guidance to law enforcement, to individuals, and to the triers of fact. But the analysis, in my view, is trying to make it as clear as possible for citizens, law enforcement, and juries to make these determinations and not allow there to be the vagueness that we submit exists
But
in
see,
the
that's not,
statute.
I suggest that that's not the standard, that make it as clear as possible. I think the standard is that, that there be reasonable notice to a person as to whether, under what criteria or what elements will his or her behavior constitute a crime. And so I don't think it's at all possible for in terms of the standard that you described. But due process notice requirement.
Right.
I want to get back to the imminent. Well, go ahead and answer the Chief Justice's question.
I was just going to respond that, under the Shimizu case, it appears that the standard is that the statute defined the criminal offense with sufficient definiteness. So I guess the question comes down to, does the terrorizing statute provide sufficient definiteness in the way that it's worded? And we say no, because no overt act, no imminence, no mens rea, no specific requirement for intent, etc.
There's no doubt imminence is not statutorily required under 9 GCA 1960. And if we were going to read into the statute a imminence requirement, wouldn't we be undercutting the legislature's intent? For example, if someone threatened to blow up a school in 2 weeks and there's going to be a bomb in the next 2 weeks. It might not be an imminent threat. Obviously, it's 2 weeks away. And so would we then say that person would not be capable of being prosecuted under a terrorizing statute of a threat of a future violence, any communications of future violence, as opposed to imminent or present violence would not fall under the ambit of conduct that the statute was likely intended to prohibit? That's a tough pill for me to swallow when we say that someone can be involved in making a threat. The threat is of future violence, and place someone in reasonable fear because of that. And particularly, what happens if it ends up being, a threat from a well-known terroristic organization? And so we wouldn't be able to charge that person with terroristic activity simply because it wasn't a threat that was imminent, because the threat was something that was going to be in the future.
Yeah, I see the concern there, and I think the point that we're trying to assert on appeal is whether it be imminence or some other definition. What we have in our view is a very broad and vague statute. And if we had if we had a little bit more, if it was more narrowly worded, it would be less vague. So if it did say imminent, then you've got a definition there in terms of time frame. If it doesn't, but yeah, the point is I acknowledge the point. But fundamentally, there are so many instances of vagueness in the statute because of the lack of the mens rea, the lack of a requirement of criminal intent, a standard of conduct, a time component, whether it be eminence or otherwise, no requirement of an overt act. I would submit, in response to Chief Justice, your comment about the statement and overt act, I would submit that the statement itself does not constitute the overt act, but the statute should require, for example, an overt act in addition to the statement. That would make the statute less vague and give more guidance to those who are trying to comply or enforce it. So I recognize there are difficulties in these arguments that we're presenting. I would just note, I've got 3 minutes and I've reserved time. With respect to the statutes that the government had, with the cases the government presented in opposition, for example, the Georgia and Pennsylvania cases of Green and Lathrop, those cases deal with statutes where you have a specific mens rea, such as intent or a purpose requirement. And with that, I would submit unless there are any other questions I might answer.
Thank you, Mr. Paris.
Thank you.
So at this time, Attorney Woloschuk, you are recognized.
Chief Justice, may it please the court. The defendant in this case is trying to shift the responsibility for what he's done onto the victim, but these are crimes that he has committed, and the people presented sufficient evidence for the jury to support the convictions that they returned. And the statute is constitutional, so we are going to ask this court to affirm the judgment below. I'd like to address the defendant's 2 issues, starting with the sufficiency of the evidence. Now, when it comes to terrorizing, all the elements of this statute were met. The defendant communicated a threat. The threat was a violent crime that would be dangerous to human life. And the natural and probable consequence was that the victim was placed in reasonable fear that he would do this to her. As one of your examples showed, as one of the examples that the defendant brought up about imminence, if she had been afraid a week later, that wouldn't be reasonable. But there are objective standards built into this statute, and all of these elements were met. I think the best evidence was probably presented by Jenny Sinke She testified that the defendant took out the machete. There was some altercation or some sort of argument. He was angry. He followed them up the stairs, and that's when he made the threat. And he was able to back it up because he was holding on to a machete at the time. So he said he was going to either cut her head off or cut her in half or do that to the other person. So this
What
is
about the
obvious.
argument that they were friends and they were, drunk? I mean, there have been a few times along the years that you've gotten angry at a friend, I'm sure, and made a threat to him. Does that then make it not reasonable? Is that the objective standard that's not met? It wasn't your friend wasn't placed in reasonable fear when you made the threat to them, and why should that be something that's looked at here as well?
Your Honor, I don't think they were those kind of friends. When she testified as to what sort of friends they were, she said friends from the street. So I think it's more that they know each other and may have had, some interactions before, but it's not like they're great friends and hang out together all the time. In this case, I think that the fact, you have to look at all the circumstances, which is that he was getting angry at her about something she was saying, and then he pulled out the knife, and then when they retreated to this, I think it's a rooftop or an upstairs area, he followed them and he had the machete out, and he could have carried out the threat because he had it in his hands, and he could have cut them if he'd wanted to. So the threat was there, and this wasn't anything friendly or, just between drunken friends. And the other proof of that is that, she wanted to call the police, and that's the first thing she did. They ran down and they went to the Hong Kong Center and they called the police. And now the fact that she later went and stood outside, that was after about 10 minutes had passed and they knew the police were almost there. Plus they stood out in the light by the street, I think, whereas the defendants were off in the corner in the dark, and they were 20 to 30 feet away, which is quite a distance. So I think by then she was feeling more relaxed. The fact that the police didn't see the defendant threatening her doesn't mean it didn't happen. This is something that happened at a moment in time, and the moment passed, but it doesn't mean it didn't happen and that he can't be prosecuted for it. Turning to the special allegation, under section 80.37, the people have to show that the defendant knowingly and unlawfully possessed or used a deadly weapon in the commission of a felony. And in this case, he's lawfully allowed to possess a machete. I mean, almost everybody on Guam's got one because we need them for, cutting weeds and stuff like that. But the way that he was using it, that was not lawful. And the trial court did not make a finding as to his use during the threat. What the trial court was doing was saying that, he didn't actually cut her, so he didn't use it in that way. It doesn't mean that he didn't use it to emphasize the threat. The reason it was a threat that was of a violent crime dangerous to human life is because he said, I'm going to cut you in half or cut off your head. And he had a machete in his hand so he could back up that threat. So that's what makes the use unlawful. And it's knowing because he knew what he was doing at the time. And it was while he was terrorizing her. So that makes it during the commission of a felony. And there's no requirement that the people produce in evidence the actual weapon that was used. Officer Corpus took the weapon off the defendant when he arrived. So he has seen it. He knows what it looks like. Jenny saw it. She knows what it looks like. Chris saw it. She knows what it looks like. So they all testified that there was a machete involved and they knew what it looked like, and a picture of it was presented. So the jury also got an idea of what kind of weapon this was. So we would submit, Your Honors, that the special allegation is supported by sufficient evidence and that this conviction should also be sustained. As for the misdemeanor assault, under section 1930, in order to commit a simple assault, All you have to do is attempt to cause bodily injury. And there's no need to actually cause bodily injury. And you can attempt to injure someone by striking them on a vulnerable part of their body. And in this case, Chris testified that the defendant kicked her in the head, and she wasn't injured, she says, but your head is a vulnerable part of your body. And if somebody kicks you there, they are attempting to cause bodily injury. So the defense can't say that there was no evidence. There was evidence, and it was up to the jury to decide whether or not to believe her, and they did. And so that that crime is also supported by the evidence and should be affirmed on appeal. As for the constitutionality of the terrorizing statute, now turning to section 1960, vagueness has to do with notice and enforcement. And in this case, the citizens and the law enforcement and the jury, they all have notice of what's required. You have to communicate a threat of a violent crime that's dangerous to human life and that strikes fear into the victim. And these are all reasonable person standards, not just what this victim thought. So if law enforcement can feel it and the reasonable person who's about to make a threat can feel it, and so can the jurors, then that's enough notice in the statute for it not to be called vague. And it's also not overbroad. The mens rea can be filled in by section 4.40. It's either intentional, knowing, or reckless. And in this case, part of the statute, it says that the fear that it puts in the victim has to be the probable and natural consequence of the threat that's been made. And when we talk about consequences, we talk about the defendant knowing what he's doing because that's the result that he's trying to get. And so the result has to do with knowledge, and that's the mens rea that is built into the statute, even if it's not actually spelled out. And that's why you can use section 4.40 to say that it's knowing, and that's why the people charged it as knowing. And
What about the Chief Justice's question is, could this be a statute where no culpable mental state needed to be pled? Or do you think that a culpable mental state is required and filled in by the filler statute?
I think, Your Honor, that the culpable mental state is filled in by the statute, because the statute says if nothing is stated, then it has to be one of those.
So if that statute did not fill in the culpable mental state, and you didn't have one, would then the terrorizing statute be unconstitutionally vague because of a lack of a mens rea?
It might be, Your Honor, except for the fact that it talks about natural and probable consequences, and consequences are what follow from knowledge. So there is a sort of built-in mens rea. It's just not explicitly stated. So I think it's better to use section 4.40 to fill in the mens rea. But even if there were no section 4.40, it's possible that the mens rea is still there. And I would also argue that imminence is there in the fact that we wouldn't find it reasonable for her to be afraid a year later, like the example said. So by having this reasonable person test, that's what tells you whether the timing is right or not. And it's also something that guides the law enforcement officers when they're trying to enforce this statute, and the jurors when they're trying to figure out whether somebody is guilty of this statute. It's not going to cover innocent conduct like friends, between drunken friends making jokes about cutting somebody up, because in that case, the fear would not be objectively reasonable. In this case, it was, and that's shown also by the fact that the victim and her friend went to the store right away to call the police. And like I said before, the fact that they went back outside 10 minutes later when the police were almost there, all that shows is that they managed to relax a bit in the moment, and they were still far away from the defendants. And it doesn't take away from the fact that the defendant made that violent threat and that he terrorized this victim. And so we would argue, Your Honors, that the evidence was sufficient to support all of the convictions of the defendant in this case, and the statute is not unconstitutional, and therefore we ask that you affirm the judgment below. Thank you.
Thank you, Attorney Wallace-Chuck. Mr. Paris,
May I ask a question?
Justice Merriman?
Could you go through what the proof was for the assault charge that proved that?
Yes, Your Honor. There's the assault statute says that you have to attempt to cause bodily injury. And so in this case, the victim said that the defendant kicked her in the head. I think I have a page number for that, so I'll take a look. It's in the excerpts of record around page 120 to 122, and in the transcript from 116 to 118. And so he said that he kicked her in the head, and she said she didn't get injured, but that doesn't mean that he didn't try to injure her, because like I said, your head has a lot of vulnerable spots on it. It's got, you know, your eyes and your teeth and, you know, temples, and it might have hit her on the neck. There are just all sorts of bad things that can happen if somebody kicks you in the head. And so we would argue from that, Your Honor, that there was proof of a simple assault here. Thank you.
Mr. Paris, I think you have less than 3 minutes remaining. We'll reset the clock.
Yes, Your Honor. First, with respect to the fourth charge, I mean, my understanding of reading the indictment was that the government's theory was the assault was based upon the discussions and the machete. So I guess perhaps when the court is reviewing this, the court will determine whether or not my theory of the fourth charge is accurate or not. Going to the case as a whole, I mean, I really view this as a blown out of proportion, overcharged case based upon drunk friends hanging out. And when we look at the specifics of what's alleged, I mean, it really sounds preposterous. We've got Miss John, who drank 3 beers in a half hour, encountering Mr. Tefong, and she's asked, can you go buy more beer? And she says she doesn't have any money. Then she says, well, then he said he's going to cut me in half or cut my head off. I mean, this is the most preposterous type of, you know, allegation, and it's clearly something not to be taken seriously. And the court touched on the reasonableness issue.
But
It's
Mr.
clearly
Paris,
not.
I think a significant other factor in reference to just fighting words are the fact that he pulled out a machete. And the burden of the prosecution is to prove that there was a communication of a threat to commit a crime of violence, and someone is put in reasonable fear that can be carried out, and someone pulls out a machete and makes these threatening words. It's a little different from just, you know, I'm just fooling around.
Well, when we look at Morales and the court's decision in analyzing the motion for acquittal, and the court talking about Morales, talked about, you know, it's not reasonable if it's blustering or if it's grandiose. And I would submit that on the issue of reasonableness, this really was not reasonable. And when we look at Miss Chris's, behavior, if she was truly fearful, she would not be staying by him 20 to 30 feet away. She would have gone back in the store, and she didn't know when the police were coming. The whole case just looks way overcharged. And I would just point out one other thing.
Would it be any difference if he pulled out a gun? The only difference in reference to the same circumstances you described, and he pulls out a gun and points it at her?
I would say there could be, because a gun is clearly a deadly weapon, and a machete is more of an everyday object that is commonly possessed by people. And the other thing I would
But
just point out.
what if the gun had no bullets? What if there was no ammunition? In that situation, it would seem the machete is a more dangerous weapon than a gun without ammo.
Well, as we're instructed by Camacho, you always look to the substance and context. So did the victim know there were no bullets? Did the perpetrator allege that there were bullets in the gun? It's context specific. And if I could just say that if the court goes back and looks at the statements that were made when Judge Bordello was analyzing the acquittal motion, you'll see that there really is a language issue here in the way that the testimony was given and the way that the Attorney General would question the alleged victim and start assuming facts in the form of questions when questioning the alleged victim. So I would ask the court to look at the manner of testimony of the alleged victim and the way the AG would jump and assume facts about how for example, the machete was pulled out or not pulled out. Thank you.
Can I go back to you keep talking about after they went in the store, then they came back out, and she didn't seem to be fearful at that point. But isn't the real question is how she perceived the events at the time they happened and not 20 minutes later? That if she was truly in fear when the events were occurring, isn't that sufficient?
I think, Your Honor, that's fair to say. Yes, but I think in this instance, the police came minutes after the police were called. And you look at again, we go to Camacho and look at the substance and context of what happened. So I think it's also fair to look at her behavior in light of the alleged threats, what she did during this period of time. But yes, I agree with you, Your Honor.
Thank you. That's all.
Thank you, Mr. Harris. Thank you, counsels. The court will take the matter under advisement. This concludes our oral arguments, and the court stands adjourned.
Thank you, Your Honors.